Okay, so before we get into this, an attorney representing three friends in the Nolan Wells case just made a claim so direct he staked his own name on it. "I'm willing to bet my reputation on that," Tyler Cox said, when asked whether Nolan's family has actually turned over his phone for examination.
Well, I think it's strange too. We were all told by Ben Crump from the steps of the courthouse in a public address, I think that was on July 11th, after he met with DA Angel Myers, that they were going to cooperate and give the phone over.
More than 5 weeks after Nolan died, and the phone still hasn't been forensically reviewed. Cox says that's on the family. The family's own attorney says that's flatly not true. Two lawyers, same 5 weeks. Two completely different stories about who's actually responsible for the fact that nobody, not investigators, not independent experts, has been able to look inside that phone. And here's the detail that changes how you should read this whole dispute. When you actually lay out the documented timeline, letter by letter, date by date, the real disagreement isn't nearly as simple as either side is making it sound. We're going to walk through exactly what Cox claimed, exactly how the family responded, and what the actual paper trail shows about why this phone, potentially one of the most important pieces of evidence in this entire case, is still sitting unexamined. Before we go further, if you are new here, this channel breaks down real documented cases using real sources, no speculation dressed up as fact. Subscribe to True Crime Revealed so you do not miss where this case goes next. Let's start with how the phone actually got to Nolan's family in the first place, because the origin of this dispute matters for understanding everything that comes after. When Nolan's friends returned from Horn Island without him, they had his phone with them. They gave it to Wells's mother, Christine Wansley. From there, according to reporting, Christine used a tracking application to locate the device's whereabouts herself before physically retrieving it. Once she had it in hand, she searched through it, and she has said publicly that she found what she believes is evidence someone had tampered with Nolan's Snapchat account and deleted messages. That single claim, tampering, deleted messages, is the seed of almost everything that's happened since. Because once a parent makes a public claim like that, it creates an obvious, urgent question. If something was deleted or altered, who did it and when? The only way to actually answer that question is a proper forensic examination of the device, one capable of recovering data, checking access logs, and establishing exactly what happened and when. And that's precisely the examination that, more than 5 weeks later, still has not happened. Now let's get into Cox's claim directly, because he didn't hedge at all. Speaking with SiriusXM host Dan Abrams, Cox said this: "I saw a headline a few weeks back that said Wells's attorney Ben Crump and the family are going to allow the Jackson County Sheriff's Office access to Nolan's phone. You know what I never heard? I never heard Crump follow through with that." He continued, "I have reason to believe, and I do believe, that Wells' family have not cooperated with law enforcement. I do not think that they have turned in Nolan's phone, and I'm willing to bet my reputation on that. I don't think they've cooperated at all." Notice the specific structure of that statement. Cox isn't simply saying the phone hasn't been examined yet. He's making a much stronger claim, that the family has not cooperated at all, full stop. That's a serious accusation, and it's worth taking seriously precisely because of how directly he stated it, staking his own professional reputation on its accuracy. Cox went further, and this is where his argument becomes genuinely pointed. He directly challenged the basis for the family's tampering allegations. "The police do not have Nolan's phone," he said. "They haven't had access to Nolan's phone. The Jackson County Sheriff's Office hasn't. So how can you say that there's texts missing, or there's photographs missing? That's a fair question on its face. If law enforcement has never had the opportunity to conduct their own forensic examination, then any claim about what is or isn't missing from the phone is, strictly speaking, based entirely on what the family and their own experts observed, not on anything independently verified." Cox also added a specific detail pushing back on any implication that the friends themselves had anything to do with altering the device. He didn't have his phone in the water because no one did, he said, adding that there was more than just Nolan's phone that wasn't on the boat with them, seemingly referencing that multiple people had left their phones behind that day, a detail we've covered in earlier updates on this case. Now let's turn to how the family's legal team responded, because this is where the story gets genuinely complicated. Not simply a denial, but a fairly detailed paper trail. Ahmad Smith, one of the attorneys representing Nolan's family, sent a letter to prosecutors specifically addressing these claims. To the extent there has been any suggestion that we have been unwilling or have failed to cooperate with the investigation, we want to make clear that this is not the case, Smith wrote. That's about as direct a rebuttal as you can get, matching Cox's certainty with equal certainty in the opposite direction. But here's where it stops being simply one attorney's word against another's and starts being something you can actually trace through dates. According to the most detailed reporting available on this dispute, there was a meeting on July 15th where a joint forensic inspection of the phone was reportedly discussed and, by most accounts, agreed to in principle, both sides examining the device together, sharing oversight of the process. Then, on August 11th, an attorney representing Wells's parents sent a letter to the district attorney stating the family remains ready and willing to arrange that joint forensic inspection, specifically referencing that July 15th meeting as the basis for what they believed had already been agreed upon. Then, just 2 days later, on August 13th, another attorney for the family clarified something that changes the entire picture. According to this clarification, the district attorney's office had, at some point after that July meeting, told the family to simply deliver the phone directly to law enforcement, rather than proceeding with the joint, shared oversight review the family believed had been the agreed-upon plan. The family says that instruction differs meaningfully from what they understood the process to be. Sit with that for a second, because this detail is the key to understanding what's actually happening here. This isn't a story about a family refusing, flatly and simply, to hand over a phone. Based on the documented timeline, this is a story about two different parties operating under two different understandings of what process was actually agreed to. A joint, mutually observed examination versus a straightforward handover directly to law enforcement. Those are genuinely different things, procedurally and from the family's perspective, in terms of trust and oversight. A joint examination means both sides watch the same extraction happen at the same time, with no opportunity for either party to later claim data was altered, mishandled, or selectively shared. A direct handover means the family would be trusting law enforcement's process entirely on its own, without independent verification alongside it. The family's attorneys have proposed a specific path forward to resolve this. Their letter specifically raised using the digital forensics lab at Mississippi Gulf Coast Community College, potentially with FBI involvement, and asked prosecutors to help coordinate a mutually agreeable date and process. That's not the language of a party stonewalling an investigation. That's the language of a party trying to negotiate the specific terms of cooperation, which is a meaningfully different thing than refusing to cooperate at all. So now let's actually weigh these two accounts against each other honestly, because that's what this video is built to do. Cox's claim that the family has not cooperated at all is, based on the documented record, an overstatement of what the paper trail actually shows. There has been a meeting. There have been letters. There has been an explicit, repeated, written statement of willingness to proceed with a forensic examination. That doesn't look like a party refusing to engage with the process. At the same time, Smith's blanket statement that any suggestion of non-cooperation is simply not the case also somewhat undersells what's actually true here. The phone has not been examined. More than 5 weeks have passed. Whatever the reason, whether it's a genuine, good-faith disagreement over process, a breakdown in communication between the family's team and the DA's office, or some combination of both, The practical result is the same. Potentially crucial evidence remains unexamined, and Cox's underlying point that nobody can currently verify the family's tampering claims without that examination happening remains entirely accurate regardless of who's ultimately responsible for the delay. This is exactly the kind of situation where the loudest, most confident public claim from either side isn't necessarily the most accurate one. Cox stated his position with total certainty, willing to bet his reputation on it. Smith stated the opposite with equal certainty. And the actual documented reality, based on dated letters and a referenced meeting, sits somewhere in between both of those confident public statements. A genuine, still unresolved disagreement over method and oversight. Not a clean story of cooperation on one side and obstruction on the other. It's worth pausing here to explain why this specific dispute, over process rather than substance, actually matters so much to the broader case. If Nolan's phone genuinely contains evidence of tampering, deleted Snapchat messages, altered data, that could be a significant piece of this entire investigation, potentially explaining part of the unresolved gap in what happened during his final hours. But that claim currently exists only as something the family and their own examination observed. Cox is right that, without an independent, verified forensic examination involving investigators, or ideally both sides working from the same extracted data simultaneously, there's currently no way for the public or for investigators to confirm whether that tampering claim is accurate, exaggerated, or mistaken. This is precisely why the family's proposed joint examination process matters so much. It's specifically designed to prevent exactly this kind of unresolved, he said, she said dispute over what a piece of evidence actually shows. It's also worth connecting this to the broader pattern we've tracked throughout this entire case. Nolan's independent autopsy remains listed as undetermined, pending additional information. The state's autopsy results still have not been publicly released. Smith's letter to prosecutors separately asks for help getting pathologist Roger Mitchell access to materials from that first official autopsy. Another example of the family's legal team describing themselves as still waiting on cooperation from the state's side, not simply the other way around. Multiple pieces of potentially crucial evidence in this case, the phone, the full autopsy findings, remain in exactly this same holding pattern. Technically in progress, formally requested, but not yet actually delivered or examined. So where does this actually leave us? As of this recording, Nolan's phone has still not undergone a forensic examination involving law enforcement, more than 5 weeks after his death. Tyler Cox, representing the three friends, has publicly and directly stated he believes the family has not cooperated with the investigation at all. Ahmad Smith, representing Nolan's family, has directly and formally disputed that characterization in writing to prosecutors. And the documented timeline, a July meeting, an August 11th letter reaffirming willingness, an August 13th clarification about a change in the requested process, suggests the real story here is a genuine disagreement over how this examination should happen, not a simple binary of cooperation versus refusal. That distinction matters enormously for how you should think about this specific development. A headline that says a family is refusing to hand over evidence tells a very different story than the actual documented reality. Two legal teams negotiating the terms of a forensic process, publicly, through competing statements, while the underlying evidence itself, whatever it ultimately shows, continues to sit unexamined in the middle of that disagreement. We're going to keep following this case as this phone dispute hopefully gets resolved, as the state autopsy results are eventually released, and as this investigation continues moving, however slowly, toward the grand jury process already set in motion. We'll bring you those developments the moment they're verified, and not before. That's everything we have for you on this update. If you want the real, documented version of this story, instead of whichever headline sounds most dramatic, make sure you're subscribed to True Crime Revealed so you don't miss what comes next. Drop a like if you think this phone examination needs to happen immediately, regardless of which process gets used, and let us know in the comments who you think bears more responsibility for this 5-week delay. Thank you for watching, and we'll see you in the next update.